Uh, My name is Tom Blackburn. I'm an attorney. I've been working for, I guess, over 25 years as an attorney. Started out in Montgomery County, working for a judge there, Judge Corso, for 1 year as a judicial clerk, and then I worked in the DA's office in Montgomery County for about 5.5 years under Mike Marino and with Bruce Castor and Risa Furman and those folks in the Montgomery County DA's office. And then since then, I've been an attorney with the small firm of Drake, Heilman and Davis, which is a firm made up of Christian attorneys located in Doylestown, and that's been a blessing to have been able to work with them. And we have interaction with a number of churches in the area, and certainly it's been a privilege to me to discuss, deal with, grapple with issues with your church. And I would also say it's a privilege just to see the church and what you've done here. I've been part of a building committee in the Conshohocken area, and I mean, this is just beautiful. So for what it's worth, sometimes people look at things and who knows what they think, but I think you've done a tremendous job here. This is beautiful, for a beautiful utilization of space in an area like this. So congratulations on that. With respect to my practice, it's kind of interesting. I've been a trial lawyer as a prosecutor, but over the years, having dealt with churches with various things, I've kind of seen, particularly in about the last 5 years, that I found a bit of a calling maybe to work with the ugly things that go on in church, and maybe to help, to be able to help where there's difficult things, where there's the 19-year-old who has a drug issue, where there's the 39-year-old single mom who has a custody issue, where there's, unfortunately, things don't always happen the right way in churches, and just things go wrong at times, or where there's a child reporting issue. And so it's been interesting to be able to work in that capacity and to really come alongside of churches and pastors and to assist churches in these very difficult issues to handle. And that's part of what we're doing here today. And obviously you've taken up this mantle on your own, and it's not an easy undertaking to say, like, we want to help people with counseling in this crazy world. So I certainly, again, congratulate you on taking up this ministry. So I also wanted to say, we're all in the same battle here, between good and evil, and evangelizing, our faith. And I've been a part of that battle, probably more so the last couple of weeks than I had, previously, as I was involved in a jury trial in one of the upper counties. I'm not going to say what or where, but very difficult case involving a single or a widowed mother, about 40, who had been alleged to have abused her children. She had been involved in corporal punishment, and she had used household instruments with corporal punishment. Long story short is that I believe that she was falsely accused of causing injuries to her children. And so even being a trial attorney, feeling like I was fighting everybody, including the judge, but with the support of prayers from all over, quite frankly. The judge, the DA's office, the Office of Children and Youth, who really did not appreciate my client at all, and I think because of her faith to some degree, and how strong she was with her faith, and also the tremendous courage that she showed, because a week before the trial, whenever they realized she really wasn't going to enter any sort of plea because she said that she was innocent, they decided to increase her charge from a misdemeanor to a felony, so that if we lost, she was going to do years in jail as opposed to months in jail. And still, she showed tremendous courage by we're going through with this, and we're going all the way with this. And fortunately, it was the jury that I think saw things the right way. again, I can't go into the details, and you might be thinking, well, how do we know that you didn't represent somebody that was lying and all that sort of thing? And I understand that. But I guess what I'm trying to say is that I think that we are all in a similar battle here, and there are times when you need to stand up and fight that battle, and I certainly felt that in ways that I haven't all the time, in our faith these last couple of weeks. So, and I also want, as we start here, I would encourage questions. In fact, I want questions. Now, I understand with the audio that could be a problem, but I would almost rather you ask questions than worry so much about the audio, because I think that will help this time go quicker. So I've been asked to talk about legal issues relating to counseling and general liability issues, first of all. I'm not sure it's the most interesting topic in the world, but we're going to try to get through this. I'm going to start out by talking about some general principles that we can discuss, and we were already discussing some of these issues before this started. And issue number one is location of the counseling from a general liability perspective, and to the extent possible, the counseling sessions should have the ability to be seen, which means, you shouldn't be in an enclosed space where nobody can look in. There should be a window so that people can see what you're doing. If there's no window, maybe the door should be open. I understand at the same time you should not be heard, so it might be difficult to find that balance, but it's best in terms of a physical plan to have a windowed office, an open door, and at least the ability for people to walk around. Second thing to keep in mind in terms of general liability is, if there's counseling that's taking place in a location other than the church, now you might not be doing that, and that would probably be wise for you not to do that, but certain situations that might happen. Again, you should be in a public location, whether it's a Starbucks, whether it's a public library. In the back of your mind, you should always be thinking, and this is looking at point number 3, who is my witness? And I know that a lot of these rules are protect the counselee with respect to the counselor, but actually why we're here is to protect you guys, right? And in this day and age, there's a lot of people out there that seem to know the system and are very willing to come up with a lie because they think you're the enemy, okay? So I think it's very important that regardless of what you're doing in the context of counseling, as you are dealing with many emotional issues, is that you always have to keep in the back of your mind, who is my witness in case somebody makes a false accusation against me? So it's good to have that window. It's good to have things going on in the church where there's people walking around. This next issue, obviously, you're probably aware of this, and I probably don't need to say this, but this day and age, we have to be very careful about any sort of touching. We have to be careful about how we would hug, particularly a member of the opposite sex, but really anybody. And you have to be very careful about any sort of physical contact, regardless of the circumstances. Then we also have to be important about compliments. Obviously, compliments about exterior, compliments about an appearance is something that we need to be concerned about. Very rare that we would do that. I suppose there are times in the context of counseling where that could be relevant, and that's something that you would talk about. But we have to be very careful about how we would talk about somebody. We would not be talking about body parts, or we would not, although, again, the topic of sex at some points can be relevant in counseling. We have to be very careful not to take that to the next level, not to ask the unnecessary question or to pry beyond what is relevant. And obviously, we would not want to be glib or joke on that sort of topic. There also might be circumstances, and I know this is probably more for like a youth ministry situation than a counseling ministry, but obviously if you are in a car, you have to think about who's your witness. and it's best to have somebody else in the car with you if you have somebody you're counseling there present. But if you're in that rare situation where you don't have anybody with you, yet you're with a counseling, and that's a situation you definitely want to avoid. But also, maybe you can be creative, and maybe you can call your spouse for however long it takes, a 10-minute drive to take somebody home or whatever, and just to be on that phone for the entire time. And you might want to have your conversation with your spouse beforehand or a friend beforehand to say, I might call you in this context because I just want to have this witness, and you might even wonder why I'm having this conversation, but I really just want you as a witness during this time period. So I think you guys understand, in this day and age, these issues are very important from a liability perspective. Duration of meetings, obviously if you have somebody who really wants to continue to have these conversations with you and go on for, a very long time, that can be a problem as well. And I think I heard you say that you're going to try to have men with men, women with women. Is that right?
Correct.
Okay. Obviously that's wise too for obvious reasons. But unfortunately it doesn't fully resolve those questions. So let me stop there. Those just are a couple of basic principles about general liability in the counseling context. Do we have any questions or anything we want to talk about on those issues? Okay. Now, I was also asked to talk about note-taking. That was one of the subjects that James mentioned. And so I want to touch base on that. Really, the purpose of note-taking is several-fold, but as a counselor, the main purpose of note-taking is to make sure that you care for the person well. And really, notes are vital, and you can see here I'm reading from the outline. Notes are vital to record issues, plans, goals discussed, as well as to quickly refresh the counselor for future meetings. So obviously, it's very typical in the context of counseling where you might meet somebody 4 weeks straight because of a very difficult issue they're dealing with. But maybe as you counsel them, you get through that issue, there might be that 12-month gap, that 18-month gap, and then again, it's going to be very helpful for you to have decent notes as to what had happened before when they returned to you to refresh your memory as to what the issues were. I'm going to go down to C here. You do need a system of some sort. Now, I think that you're working through that as well, and I'm not sure that there is a resolution on that in terms of a system for keeping records. Did you discuss that you think people are going to keep their individual records, or?
Right, correct. Our counselors will keep individual records while they're counseling and probably should turn them in when a counselor is done with a counselee so that we have them on file probably.
Okay.
Would that be?
I guess I would have assumed that at least the church would keep records, but as opposed to independent records, if you just for purposes, if records are subpoenaed, it might be very difficult to get those records back, and it could be fairly chaotic. So yes, I think I would recommend that. I know that can be a pain for a number of reasons, but I'm going to assume that there's some system of maintaining records of the notes of the counseling sessions. And obviously these records are confidential, so they have to be kept in a way that is confidential, locked. At the same time, they need to be accessible by the right people, only by those people that are authorized. And there has to be some sense of organization to them. Sometimes the records need to be flagged. One file, for example, this person might be in a relationship or even be in a marriage, and they might not want the spouse to know that they've had this counseling session. So you have to be careful that you're not, calling the spouse. So you might need some sort of a system to flag a file so that there's notice of that. I think you talked about a physical file as opposed to an electronic file. I think that is fine for a purpose like this. but obviously there's other types of electronic files that can be utilized. Again, I'm not saying that I have all the answers here in terms of how you want to do that, or I'm not a counselor, so I don't know exactly how their typical counseling records are maintained. But you need to understand that ultimately these records could be subpoenaed for whatever reason, and there should be some system at hand where you can access those records. Since I was asked to discuss the question of taking notes or taking progress notes, I am discussing that. I guess there's two common ways that secular counselors take notes, and you guys might be familiar with this more than I am. There's the DART method, and there's the SOAP method. Anybody here familiar with those methods? Okay. Well, DART is a description of client and situation. That's D. A, assessment of the situation by the counselor. R, response of the counsel to the assessment. And T, treatment implications and plans. SOAP, these are all fairly similar. S is for subjective information about client's situation from client's perspective. O is for objective, eternal data discussed and observed. A is for assessment, counselor's evaluation, interpretation of the subjective and objective accounts. And P is for plan of treatment. Now, I actually had a conversation with a good friend of mine who's a counselor, and I won't say the place, but a Christian counselor. You probably are aware of it. And she's been doing this for a number of years. And she talked about how really the DART system and the SOAP system doesn't quite do it for them, because they need a method really to incorporate their scriptural understanding as to what's going on. And so she just uses this next example, which the first category is significant information, which is essentially why the person is there, the area of concern, key statements, situational, crisis, maybe the sins that are taking place, how God is being gracious. Essentially, what the presenting problem is the first category. And then the second category, then there's the opportunity really for the biblical interpretation of what's going on. And also maybe even a discussion as to what the status of that person's faith, how they're dealing with it, whether there's any faith there, whether there is faith, whether there's a struggle, and ultimately what the counselor believes is happening. So she's calling that interpretation. And then the last category is goals, where there might be a plan, there might be a homework assignment, there might be a long-term plan as to what you're trying to accomplish with the counseling. So I don't know if you guys have put much thought into that in terms of how your notes are going to be developed. I'm not suggesting one way or the other. The SOAP system, the DART system might totally work for you. That's totally fine. But here's some other ideas to think about. There are some legal concerns as you write progress notes. You need to fully understand that these notes could be evaluated, by a lawyer that subpoenas the notes. These notes could be used in court. Sometimes when lawyers get notes like this, it might be just two phrases, one word that in these notes that really turns the case. So now maybe that's fine, because maybe that's the word that was the truth, and maybe that it should have turned the case. But you always need to, as you're writing notes, you need to think, well, there's like a mini judge sitting on your shoulder and overlooking what you're doing. And so you just don't, you want to be succinct. I mean, you don't want to be overly verbose and go all over the place with respect to the notes, because there might be too much of your personal input when you're doing that. There's the law of unintended consequences. You might think that this area is important, and all of a sudden you've entered into an area that might have significant ramifications for custody or something like that. So you want to be succinct. I made a statement here. What you think is funny or interesting could be devastating evidence against a client in a hearing. Also, as individuals, we have a tendency to exaggerate sometimes in our language. We have a tendency to embellish, and that's just common, in our cultures, is to embellish. But we have to be careful not to do that when we're writing notes. We have to make sure that what we're saying is careful, and that the language that we write down is accurate. We have to choose words and concepts wisely. Obviously, we have to speak the truth. Definitely, we need to speak the truth, but we also use discretion at times. You don't necessarily have to put down everything that is said, or you don't necessarily have to put the person in the worst light possible. You need to, at times, use discretion in how you write these notes. The people are coming for you for help, and you don't, in these notes, you don't necessarily want to set them up for significant, problems down the road, should there be an issue. And you also want to take some time to think about, I don't have this written down, but to think about the church as well. So you need to be careful. There are times when you will need to say things that are potentially negative, that could hurt the client or that could hurt the church. But you need to think. You need to think if that's really necessary. When you're drafting notes, or are you just maybe being overly verbose and trying to get everything down that was said or whatever. So you need to use discretion in how you write these notes, because they could be ultimately viewed and they could have an effect down the road. Any questions about that? Okay. Okay, there was a clock up there. Okay. All right. Now, I've also been asked to talk about the Child Protective Services Law. Are you guys familiar with the Child Protective Services? To what extent are you guys familiar with it?
I was a mandated reporter.
Okay, so you've been a mandated reporter. We can spend a lot of time with the Child Services Protective Law, and I'm not sure that you want to spend a ton of time with it, but I want to try to go through this. And there are some materials here that I don't intend to go through that you can have in case you feel that this would be helpful to you. I think typically that if you are involved in a counseling ministry that's meeting regularly, you probably, now there's a certain gray area when it comes to the definition of who is a mandated reporter. I have some of the definitions here in the outline. A person licensed or certified to practice in any health-related field under the jurisdiction of the Department of State, an employee of a healthcare facility or provider licensed by the Department of Health, etc., a school employee. With number 6, with respect to a church, any clergyman, priest, rabbi, minister, spiritual leader of any regularly established church or other religious organization. Number 7 is probably most important, an individual paid or unpaid who, on the basis of the individual's role as an integral part of a regularly scheduled program, activity, or service, accepts responsibility for a child. Now again, you're not necessarily, is it your intention to counsel children or no?
No.
Okay, so maybe you aren't under this category then, a mandated reporter. But some of you probably are mandated reporters anyway through other activities. So you still need to think about some of these principles. And there are times when this issue is going to arise, probably in your ministry. How could it arise? Let me just open it up, and again, I apologize for the audio. But how how could this arise in the context of being a counselor?
I'm counseling someone who says that their spouse is abusing a child,
Yes.
possibly.
Correct. Any other ideas? That's one that's probably the most common. Sometimes you have situations you don't expect. Sometimes you have a situation where you're counseling somebody, and I've had a situation similar to this. Not to me, but a statement was made to a counselor almost 19 years after the fact, where he said, 19 years ago, this is like somebody in their mid-30s, when I was blank, I was 18, I remember a situation where I was with a child and something happened that shouldn't have happened. And then all of a sudden, that counselor has a responsibility pursuant to the state reporting laws to report this person for something that happened, a number of years ago, and that ultimately led to a prosecution. So these things can be very significant. So what the person, you could also be talking to somebody and they could say, that guy, and it has to be somebody that's actually named that that guy, abused me whenever I was 17, whenever I was 15, and then all of a sudden, that if you are a mandatory reporter, then there would be an obligation to contact Childline. And under Pennsylvania law, if you are a mandatory reporter, and by the way, that would include all employees of the church, all the employees of the church would be mandated reporters. If you do not report, then you could be subject to a misdemeanor or felony offense. You can be prosecuted for failing to report. So these are fairly strict laws. Some of the issues that arise, unfortunately, whenever you make a determination, if the church encounters a situation and is like, do I need to report this or do I not need to report this? Or if you're a counselor and you're talking to James or whoever and you say, something happened and I have to make a decision as to whether or not to report this. Sometimes the situations is gray as to whether, is it really child abuse? Is something that, for example, if a 12-year-old inappropriately touches a 13-year-old, and is that child abuse? And if you look at the laws, it's not necessarily child abuse because you're talking about a child on child, and it's not necessarily child abuse. And sometimes you have to look very closely at the act and go through the entire statute to be able to correctly make a determination as to whether this is something that requires a mandatory report. The basic standard for when to report is when the person has a reasonable cause to suspect that a child is the victim of child abuse. But again, the statute sometimes leaves a number of questions open as to whether or not it is something that needs to be reported. If you believe that you do have a reportable offense, that would be, you can call Childline. There's a number in this outline. Typically, then the state would follow up on that, and whoever reports it, that's confidential. If you are the mandatory reporter and you report it, it's confidential, so it's not something that is open to the public as to whether or not you've made that report. Obviously, that creates a lot of problems for churches when they have to make these reports, and that can be fairly difficult. As a counselor, there's no privilege for a counselor, meaning if somebody were to confess child abuse to you, that's not privileged, and you would still have to report. Now, if you were a pastor and somebody comes to you and is very repentant and it's a one-on-one conversation, that would be privileged. But if you're a counselor under the current law, that is not privileged. So any questions on that? I covered that very quickly. There's a lot more detail I could go into with that. Does anybody have any questions on that?
I don't know what kind of detail you may still go into, but what is the process once that takes place? Say I was to report something. What if I'm wrong? What if I was wrong to report it? What would take place? What would happen to the person that I reported or that the report was made against?
Okay, very good question. Essentially, that sets up an investigation. That call or the filing of that document with the state sets up an investigation. Now, the extent of the investigation depends upon them, and sometimes I don't understand why sometimes they hardly do anything at all, and I've seen that. It's almost surprising that they don't do anything at all. Or sometimes it becomes a very extensive investigation where there's contact with the police, there's contact at the home. I mean, often you do get whoever the allegation is made against, there will be some form of contact and a request for a statement. So typically, the person is investigated. There's a 30-day provision that can be extended where the Office of Children and Youth, as a result of that investigation, has to make a determination as to whether the abuse is founded or not, or indicated. And if there's a finding of indicated, that goes on your public record. Now, you also have an opportunity to appeal that finding. And again, this can be a fairly extensive process, and it can be a very difficult process. But the individual can appeal that, and ultimately there would be a hearing in this county or in this location. The hearing would be down to Philadelphia Department of Human Services. But there would be some due process where they would have to prove, the Office of Children and Youth would have to prove the case, and it can be overturned. But obviously, if it's a false claim, it's a really vicious thing. It can be extremely difficult to combat against it. And obviously, at the same time, the law has done a lot of good to manifest abuse in various contexts. So it's one of those laws that has a good side, but it also has a darker side too at times. Just because of the false claims and some of the friction that it causes as well, I think, that might be kind of an unintended consequence of the statute. Now, I could go into more detail about that, but I think I'll pass at this point. But I'll leave it at that. Did I answer your question? Yeah, okay.
Yes.
Okay. Anything else? You've also asked me to discuss really various issues in our culture wars that are going on. I don't pretend to be an expert on these issues. You guys are probably just as much of an expert as I am, and you have your own opinions as well. I think that it's important for you to understand that this ministry, as I understand it, is an umbrella, is part of the church's ministry. So since it is the church's ministry, you have a right to, cite scripture. You have a right to speak the truth inconsistent with your religious beliefs. So with the current questions of transgender, single-sex marriage, all the issues that are taking place, you certainly have a right to speak scriptural truth in the context of your counseling. And you can be free to do that. Now that doesn't mean that somebody can't get upset. It doesn't mean that somebody can't try to create a problem. It doesn't mean that somebody can't file a lawsuit against you. It certainly, anybody can file a lawsuit for whatever reason they want to. But what it does mean is that you have a defense because you are practicing your religion. It's part of this ministry, it's part of the church, and you have a right to speak that, consistent with your religious faith as you are counseling these individuals. And the individuals are also signing a release that they understand that you are counseling consistent with your religious belief and that you're going to be using biblical principles in the way that you are counseling. So you need to understand that you can speak truthfully, consistent with your faith, to the people that you are counseling. You should still be careful. You should be. You need to use discretion in how you do that, and maybe there are times when it's not appropriate. Maybe you should lay off in terms of a certain verse at various times. But I guess you need to understand that you have a right to speak the religious truth to the people that you're counseling. Any other follow-up on that? No? Yes? Again, you need to understand that it does seem like that this culture war is progressing pretty rapidly. And so you shouldn't be surprised about potential threats. It's possible that people will come here, wanting to do harm. And that might be their motive if they know that there's a Christian counseling ministry going on. Sometimes individuals seek organizations like this out. So again, I appreciate the fact that the church is starting this ministry, probably fully understanding that these things can happen, and that's what a church is supposed to do, really. We're supposed to speak truth in the world, and I think it's good that you're doing this. I have a couple of other issues here. When we speak of the LGBTQ group, it does seem like a lot of the things that and other progressive groups are doing ultimately might have the end result of really limiting freedom of speech, limiting Christian liberties, if there's unfavorable judicial opinions, if there's unfavorable litigation to Christian liberty in the future. Some of these positions that are being put forth today, could become law, so that if you're standing in a pulpit and you speak the truth of Romans 1, or on the question of homosexuality or something like that, you could be specifically in violation of the laws, of the country. So, and people might say, well, the Constitution is always going to protect our right to religious liberty. And I would suggest to you that it seems like what is happening is that is true, that in even both sides, whether Republican, Democrat, conservative, progressive, whatever, are going to say that you have a right to religious liberty. It's just that one side is probably going to put that in a box and say, yes, you have a right to religious liberty, but of course you don't mean that you have a right to have this opinion, about a same-sex marriage, or this opinion about transgender or whatever. So essentially that is what, in my view at least, and this is more of a personal opinion, could it potentially be used to really suppress Christian liberty and suppress freedom of speech. Any questions on that? I'm probably getting, I didn't really intend to get too political here, but that was, I don't know if you wanted me to get into some of that or not, James, so. Okay, all right. There's the whole questions of critical race theory, and I know that that's a hot issue in churches right now. I think that churches really need to evaluate critical race theory. I'm a strong believer in what Martin Luther King talked about, the colorblind society, that we're judged by the quality of our character and not the color of our skin. And the more I look at critical race theory, it seems to me that they are making critical race theory does make distinctions. It's the very opposite. It's really antithetical to what Martin Luther King said. Martin Luther King's theories came right out of Scripture. When he talked about the colorblind society, it came right out of Scripture. And those I think those theories ring true, and that's why I think that he's held in such high esteem. But then when you start looking closely at critical race theory, you are judging now on the color of skin. You're making assumptions as to what people are thinking and what their intentions are and what their motivations are. And you're also going back to kind of a Marxist belief of the oppressor and the oppressed, and they even admit they admit that they're going back to the idea of the oppressor versus the oppressed and the Marxist ideology. So this is something that's coming up in Christian circles, in the churches, and it is something that is divisive. I've had the opportunity, I was going to say something, maybe I shouldn't on the tape here. Could you turn that off for a second? That, any questions? Any discussion issues?
I have one, if you're able to speak to this or not, but in a society where suicide is flippantly used by so many young people, how does that fall under any sort of reporting, or say we have somebody who comes in and says, I just want to kill myself. As a counselor, does that fall under mandatory reporting? Does that, to what extent should we report situations like that? Are you able to speak to that at all?
I can speak to it a little bit, but not a lot. Obviously, if you have something like that, you have suicide hotlines. There's also the possibility of a 302 petition where anybody can file where they would have to be evaluated at a hospital, and then potentially after being evaluated, having a psychiatric evaluation, then there's a possibility for them being inpatient. I totally agree that this is a big problem, particularly for this generation right now. It seems like a lot of people are struggling a lot with that right now.
As counselors, to what extent, I guess my question is, to what extent do we allow the talk to take place, especially if we're taking notes, they're having suicidal thoughts, to where if something were to happen and they were seeking counsel from Clarence, say, and they subpoena notes, so at what point would you suggest, or can you counsel us as to, how would we deal with a situation like that?
Could you repeat the question again? I'm sorry.
As we're counseling and as we're taking notes, so somebody comes in and says, you know, I'm suicidal, I've been suicidal, I'm okay now, we're taking notes, and as, you know, the 12 weeks progress, there's ups and there's downs. At what point should we do anything with the potential with, you know, sometimes maybe our gut says, I'm worried about them this week.
Right. Obviously, it's a really difficult question to answer, and sometimes you're going to need, I think it's helpful to have conversations with other people, either here, and one thing I was going to write down, and I think I forgot to write down in this outline, was whenever you need to recognize that other help might be proper, and you know, somebody more experienced than you would be a good idea as well. But I would say there are times when you just don't necessarily want to leave it up to your own judgment. There are difficult situations where I just need to talk to another attorney or two just to help me, to make sure that I'm seeing things correctly or that I'm giving the right advice. You know, there are certain situations where that comes up. I'm sure this is one of them. When you're struggling, like, this could go either way, and it's true. It's absolutely true. It could go either way. But that's where you need to, you know, to have conversations. Be careful about the confidentiality of those conversations, but to try to get support and for one way or the other. Again, maybe does it mean having conversations with family members, people that might know these people, you know, to get a better understanding? Maybe that would be helpful. But at the end of the day, you probably want to be safer rather than sorry in that situation, and whether that means, you know, talking to another counselor, having them talk to another counselor who might know a little bit more about the situation or have more expertise, or even filing a 302 petition if you think if it's really that serious, then to go ahead and do that.
Thank you.
Tom, you mentioned, whoa, that's loud. You mentioned that if somebody comes in, say they're 30 years old, and they tell you that they were sexually abused when they were a minor, you mentioned that is that our responsibility then to report that? As they're already an adult, wouldn't it be more their inclination to report it, maybe us encouraging them to do that?
Okay.
I'm confused by that.
Okay, I think the answer to that question, it's a very complicated, the statute is not all that clear on some of these things, but my recollection, and I've had some cases like this, technically, if you actually apply the law to that situation, you have a 30-year-old who says that when I was 7, my uncle abused me, okay? And I'm assuming that you are a mandatory reporter, okay? I think that technically there is an obligation to report that. There's no distinction in terms of number of years, and because whenever the abuse took place, he was a child. I mean, that's. I do find that every question, I need to go back to the statute and just look at it again to make sure. So it's not something that's easily memorized, and you know, everything is unique. But go ahead.
So I guess it's my understanding now that there's no time limit on this. There used to be, of course, when I was a police officer a very long time ago, there were statute of limitations, and then that had actually opened up, but it wasn't a forever thing. So there are no restrictions as far as years past at this point, as long as that individual was a minor, was a child when it happened.
That's my understanding.
Okay.
Now, there's the statute of limitations has increased substantially, you know, in certain situations.
Right.
So yeah, that is my understanding.
Okay, thank you. And getting back to the 302 commitment, And again, when I was a police officer,
Who were you a police officer for?
oh, where wasn't I would be easier to say. 5 years in military intelligence, and I ended up in the county detectives in Bucks County.
Okay,
Al Rubenstein,
okay.
yeah. So for 302, if the person was a clear or present danger to himself or other people, that was generally, a threshold that we used to use. And of course, there was all sorts of other things too. If the person was intoxicated at that time, that had bearing on all of that. So would you defer that to anyone? I mean, if we thought that there was somebody, we used to get calls all the time from people that said, hey, this is my son, this is my friend, and he's threatening to do this. And then we used to actually draft a 302 on behalf of an individual that was reporting to us.
Well, I think that you've had some experiences on the ground, that are, I've never 302'd anybody.
Okay.
And it's rare that we get involved in that situation at that point in time. So
Right.
you truly are, the police officers that comes to the house and the person's drug, is under the influence of, drugs and is totally out of control. It takes a lot of discretion to figure out
Right.
when to let them sleep it off and when to make that move. And sometimes you're right, and probably occasionally you make the wrong move, but that's a hard one. But
Well, I mean, lots of times we used to let the people from Building 50 make that assessment, just present the facts to them, or defer to our attorneys, in the county. What do you think we should do in this? Give them succinct, summary of the facts and let decisions be made collaterally rather than.
yes,
I think we used to call that CYA, I think it was.
I understood. Understood.
Thank you.
What? I'm good. I don't have more to cover. So any other questions you have, I'm certainly willing to take them.
I was wondering if you would advise that there be one person in charge of the counseling ministry to do the reporting. And I know one of the things I always stress to us is the fear that we have that something could come of it, but we're mandated to report a suspicion, right? A reasonable suspicion, because you use that word. So it's not our job to decide if it's real. It's our job to report a suspicion to protect a child. So when I worked for Head Start, we had to go through someone else involved with the head of with our organization, and often they did the reporting on behalf. And would there ever be a case that they should consider possibly making a call to you?
Yeah. Okay. So, there was a change in the law about 7 years ago now. Are you aware of that? Okay. Well, there's a change. So probably, I don't know when you were at Head Start. Okay. So that used to be the case, that if you're part of an organization, it would be the head of the organization that would make the call. But part of the new law is that all mandatory reporters are essentially responsible. Now, that doesn't mean that, if you're part of a school and there's 6 people that know that this happened, that this was reported to, that you need 6 reports. I think as long as there's a report coming out of the school, that's probably okay. But mandatory reporter, even if they are under the supervision of somebody, perhaps so that the supervisor doesn't want something reported, the mandatory reporter is still responsible to report. So, and you are correct that the mandatory reporter is not the one that necessarily makes the determination as to whether or not it happened or not, and that's where it can get really difficult. In theory, a mandatory reporter may not fully believe what's being said, but the fact that it's being said might impose that obligation. And again, there's certain areas of discretion, but that might put that obligation on you to go ahead and report. But it's not, all mandatory reporters are obligated to report, even if their supervisor does not want to, that they're still obligated. And there are certainly times when I had a situation today. I'm not going to say what the situation was, but I had a call from a church and spent an hour talking through a situation, and whether or not, part of that issue was whether or not to report, to call Childline. So after the conversation, the determination was, that they should call Childline. So yes, certainly it's okay to seek counsel in that situation. And in fact, one of the benefits of doing that is now that pastor, or sometimes if after discussion with counsel, it's not determined to be a mandatory reporting case, okay? And I might write a letter that says this is why this is not necessary to report for whatever reason under the statute. The pastor has that letter in his file. Should something happen and they come back and say, why didn't you report? Well, I didn't report because I went to the attorney. The attorney looked into it, gave me a legal opinion that I did not need to report, and here's the letter that he sent to me. So it gives the pastor that protection that he essentially did the right thing, and then it becomes it's on me really if I mess that up. Yeah. Don't want to belabor anything. So, any other questions?
How do you see lay elders, unpaid elders of the church? If pastors are considered mandatory reporters, how about the lay leadership?
Lay leadership, lay elders, I think are unfortunately, when I say unfortunately, I'm not eager to be a mandatory reporter. I am a mandatory reporter because I represent churches and I represent schools at times. So I am a mandatory reporter, and that just puts obligations on me now. And if I don't, I'm now kind of an agent of the state. If I hear something and see something, if I don't report something, I could be arrested and charged. So I don't necessarily like that. Having said that, if you're asking me what the law says that if you're involved in a ministry that oversees children, I think probably, and you're regular and you're part of the administration, I think that an elder would come under the category of mandatory reporter. I think a Sunday school teacher would come under would be a mandatory reporter. The head of a nursery would be a mandatory reporter. But if the question is a nursery worker that shows up once every 6 weeks, I'm not sure that person is a mandatory reporter because they're not necessarily regular, regularly part of the program. Some of that is gray and discretionary. There's no clear answer on some of that. If you're a little league coach, you're a mandatory reporter. If you coach youth basketball, you're a mandatory reporter. But because your church has a youth group and you're in leadership, I think that does come under the law of mandatory reporter.
Thank you.
Yeah.
Anyone else? Thank you, Tom.
You're welcome.
I'm really grateful that we've had the time here tonight. I know that I personally am walking away with an importance of just how we keep our own records, how we as individual counselors keep records and how we'll have to somehow, maintain them better than maybe what we have started doing. But I'm grateful. Thank you for your kindness in coming and for your help towards us and for us and your continued work with our church, and we are very grateful. Thank you.